Hi, everyone. I'm Terry Moran. Our top story this hour comes out of the election. Today, the Michigan Supreme Court rejected an appeal, which was brought by Michigan's Secretary of State and several voters who are seeking to bar former President Donald Trump from the state's 2024 primary ballot for his effort to overturn the 2020 election, culminating in the January 6th attack on the U.S. Capitol. The court said in a 3-0 opinion that this challenge was not, quote, ripe or ready to be decided at this point, and because the judges were not persuaded that the questions presented should be reviewed by this court. Michigan's Democratic Secretary of State Jocelyn Bennett says it shouldn't be up to her or any other elected official in her position to rule on these challenges. In a Washington Post op-ed in September, Benson writes, quote, the nearly universal view of those who want secretaries of state to unilaterally keep Trump off the ballot is, quote, misguided. And Michigan Secretary of State Jocelyn Benson joins me now. Thank you for being with us. I should correct what I just said. You were a defendant in this case because you don't think it's your job to remove any candidate's name from the ballot, and it was these voters who were trying to get you to do that. So what's your reaction to today's ruling?
Well, thanks for having me. I think it's clear the court affirmed our position that my office as the Secretary of State, I am the chief election officer, but the law does not provide me with the authority to delve into this really thorny and complicated legal issue. And the court affirmed my decision in that regard, that unless the U.S. Supreme Court rules otherwise, the former President Donald Trump will be on our primary ballot. Interestingly, the Michigan Supreme Court also, though, indicated that the timing of this question may be premature, suggesting that we may see another round of challenges if Donald Trump is the Republican Party's nominee and comes back with the question of his qualification to serve on the ballot in the general election. So this isn't over, but the question of who should decide squarely still remains in the courts, not with election administrators like myself.
Got it. Well, let me follow up on that. So Michigan law, unlike Colorado law, which does provide the Secretary of State of that state the authority to remove people from the ballot if they aren't properly qualified or if they affirm something that isn't true, Michigan state law doesn't empower you as the Secretary of State there to do that. What would be the difference in the general election? Could you step in the general election, or is this something that the courts of Michigan will have to decide?
Well, notably, the primary law in Michigan for presidential primaries says that any individuals generally advocated for by the national media to be potential presidential candidates should be on the ballot. And so that's the law that the Supreme Court in Michigan here and all the other courts were looking at in our state, which there's nothing about qualifications. It also bears to witness that this particular qualification challenge is a little more nuanced than a more simple cut and dried issue where the facts are clear in terms of a candidate's age or place of birth. This is a much more nuanced decision about what's an insurrection. Did this candidate engage in an insurrection, and what the 14th Amendment really says with regards to that. And that, again, is why, with the nuances of that issue, it's all the more appropriate that the court and ultimately the U.S. Supreme Court should decide that. But it's just notable that in the dissenting opinion, Justice Welch also notes that this is a decision in Michigan that only applies to the primary, and that indeed, if there's a general election question, then there will be an opportunity potentially, if plaintiffs bring a case, to revisit the president's qualifications to be on the general election ballot should his party nominate him to be on the ballot at that time.
Got it. So, Secretary Benson, this is a hot potato for courts, right? With the exception of Colorado, a lot of courts are saying, we don't want to deal with this at that point. We're seeing dismissals on procedural grounds, as they have done in Michigan, and none have called that Trump engaged or incited an insurrection. There was a trial in Michigan that did so as well. But do you think the courts are reluctant to take this up simply because it runs against the American sensibility that voters choose presidents, not judges?
Yeah, I mean, this is actually, I say this as a former law professor and dean of a law school. None of the way in which this is playing out in the courts is surprising either. The courts are rightfully reluctant to both engage in what is often termed as a political question, best left to the voters in terms of a candidate's qualifications. And then also you have the very sort of nuance and novelty of this question. This has never been presented before, and the magnitude at which this is being presented is quite significant for our country. And in general, there's a philosophy authority and legal jurisprudence that if there's uncertainties about whether someone should have access to the ballot, you decide in favor of giving the voters the choice to and allow that person on the ballot to give the. So you see that playing out a bit here, I think, in the many states that have declined to go forward with this challenge. This idea that in a democracy, voters should ultimately decide who should be, in this case, president, is a big part of the way in which this question is playing out nationwide.
For sure, and rightly so. Now, you're Secretary of State of Michigan, the state's top election officer. You're also obviously an elected official. You won a statewide election in Michigan, Secretary of State. In a lot of states, that's a stepping stone to the governorship. I won't ask you about that, but I will ask you about whether you think, from putting on your politician's hat as a candidate and as a successful Secretary of State, is this dumb for Democrats to do? Isn't it just making Republicans angry for taking away their choices at the ballot box?
Yeah, again, usually if there's an issue of qualification that's cut and dried, like is someone's age or past service through term limits disqualify them, then everyone agrees on the facts and the law, and it's much easier and clear cut to make a decision about ballot access that would deny someone that access. Similarly, if someone didn't commit enough or submit enough signatures to be on the ballot, if that's what the law requires, it's much easier to make a clear case in that. This case is so complicated and creates so many questions of facts and law that are not universally resolved that it's a lot more complicated even for courts to weigh in on. And so, I think we'll see how the criminal proceedings play out with regards to Donald Trump that are still ongoing. And I think, in my view, no matter what and how this legal qualification issue plays out in the courts or at the U.S. Supreme Court, voters have the ultimate authority and should have the ultimate authority to decide with their power who should become president. And I think that's ultimately what voters observing all of these proceedings need to think about in terms of how they're cast their ballot, certainly in the primary stage of this process, but also potentially in the general election stage.
I think that is what most people probably feel deep down. Michigan Secretary of State Jocelyn Benson, thank you very much for helping us out with an important ruling today. Appreciate it.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.